Well, all this week, Mercy, we've been looking at the issue of family feuds over wills and estates and power of attorney. We asked you to email us questions, and here to answer them today, Jordan Atin back again. He's the author of The Family War. Great to have you here. And I know you've answered some emails online, though, correct?
That's right.
So let's get to some there we can do on air, and ones that we think a lot of people may relate to. And one is from Monica. My father remarried and left all his belongings to my stepmother. Since he died, the house has been sold. We've had no contact with her. Do we have any legal grounds to sue?
Yeah. It depends, I guess, how Dad did his will.
Yeah.
Usually what Dad would do there in that situation is he'd either leave it directly to stepmom, in which case stepmom can pretty much do anything she wants, or he would have put it in a trust for stepmom, so that stepmom got to use it during her lifetime, and then whatever was left went to the kids. You do that for tax purposes. There's not usually enough money to give it to the kids and to the spouse at the same time. So, so what we would recommend in that kind of situation is use insurance if you can to provide for the kids, so they're not waiting around for stepmom to die in order to get their inheritance.
Our second email is from George. What happens when your adult child and their partner receive a significant sum, such as a house, and then there's a breakup and the partner ends up with 50% through no contribution of his own? Yeah.
This is a big fear for lots of parents. And what we explain to them is that inheritances are generally not going to be split between the beneficiary and their spouse if they break up. Usually they're excluded. The problem is that if you take that money and instead of keeping it separate, you give it to your spouse, or you put it in a joint account, or worse, you put it in the matrimonial home, you buy a home with it, or you pay off the mortgage, then you lose that exemption, and then you'd have to split the inheritance.
Interesting, very good. Judy, if two people are both named as powers of attorney, does each need the other's permission to act?
Yeah, it depends how the power of attorney is written. If it says A and B are appointed as powers of attorney, then both have to act together. But if it says A or B can act, then either can act independently of the other. And it's not a bad idea to do that in the sense that you have two people looking over what's going on. So if you're concerned about abuses, that's one way of making sure there's a check and a balance there.
Here's another email that we have from Marlene. My sister is in a common law relationship. If she has only named her children, in a will, can her partner's children contest it?
Well, the first thing to understand is, as long as she doesn't marry this new person in her life, then the will stand. Because if you marry somebody, that revokes a will automatically. But if they're common law spouses, and it depends on where you live about how long you have to live together, but if they are common law spouses, that spouse can challenge the will on the basis that it doesn't provide anything for the spouse. And you can't cut a spouse out necessarily if they're a dependent of yours. So as long as they're dependents of yours, they're entitled to go to a judge and say, I want support from this estate. And a judge will determine how much support that common law spouse could get.
And just make sure that if you are leaving a will, you are as specific as you can be, correct?
Absolutely.
Yeah, okay. Yeah. Jordan, this has been a very interesting week. Thank you so much for everything.
My pleasure. Thanks a lot.
And he's answered more emails online. You can read them by going to our website, canadaam.ctv.ca. Coming up, find out if you should rush out to see Pineapple Express. Richard Krause has a review of the Stoner film coming up.
A cop, a lady, and a guy. A cop, a lady, and a guy, man. That's like